Here at Project Veritas, we have won a historic battle in a defamation lawsuit against the New York Times and New York Supreme Court, not granting motion to dismiss against the New York Times. This is extraordinary. A lot of people are talking about it. Fox News, Daily Wire, Washington Examiner, Zero Hedge, even President Trump brought it up.
Congratulate Project Veritas on their big win on the New York Times. Now the suit will continue.
Constitutional law professor Jonathan Turley saying he expects to, quote, teach the case next year in his own torts class when he deals in defamation. Now, many of you wondering, why is this such a big deal? Because to get past motion to dismiss in a defamation lawsuit against the New York Times is such a big win. Listen to this Canadian lawyer on YouTube tell you why.
The absolute state of defamation law in the United States is that it is a victory simply to be allowed to continue suing for defamation.
So much to tell you. We're going to take you through this judge's order, and we're going to give you the full details right now. This is the 8th time in more than half a century that the New York Times has lost a motion to dismiss without appeal. And we've learned this is the first case ever where the New York Times lost under New York's new anti-SLAPP laws enacted last year. Now, because we've won on this motion, we get to do discovery.
The decision by the state Supreme Court, which is a trial court, allows Veritas to take the depositions of relevant New York Times employees, which Veritas founder and President James O'Keefe said he would record and expose.
I mean, America, this is what you've been waiting for. Now we get to open up the New York Times' newsroom. They're the ones in the hot seat. Now we can shine a light into their practices and what they're doing under oath and videotaped. How did we do it? We had the help of one of the nation's best defamation lawyers, Libby Locke, who helped us sue the New York Times last fall. If you recall our investigation on the Minnesota ballot harvesting videos, which were self-evident, clear as day. It was all caught on tape.
Last year, Project Veritas, the journalism group, published a series of videos documenting what looked like voter fraud in Ilhan Omar's congressional district. In one of those videos, the brother-in-law of a Minneapolis politician is seen bragging about collecting hundreds of absentee ballots in his car.
Numbers don't lie. Numbers don't lie. Waujeedan gaarigaygu waa buuxaa waxaas waa absent ballot salka yaala soo ma jeedin. Fiiri.
Other footage showed Minneapolis officials acknowledging that political operatives were paying elderly people for their mail-in ballots.
End of the street,
Yes.
there's 3 towers called 1 tower.
Okay.
And it's all seniors, and they took every ballot. The money was brought by Ali Ghani. Ali Ghani is the campaign chair of Ilhan. He's a staffer in her office.
It's got to be illegal, right? But it was happening.
That's illegal. Why?
We don't get it legal.
How much are we?
So almost immediately, the New York Times dispatched one of its reporters to shut it down. The Times reported that the footage from Project Veritas was part of a, quote, coordinated disinformation campaign. As a matter of fact, the Times declared, Project Veritas's videos were, quote, deceptive.
Now, you just saw evidence of a man with ballots all over his lap. It's illegal in Minnesota to obtain more than 3 ballots, to have in your possession more than 3 ballots. And the New York Times bizarrely looked at the same video, which you just saw clips from, and said that we were making claims without evidence. You can see their faces. You can see the faces of the man who exchanges $200 cash, and they lied. And they said that we relied solely on unnamed sources. Now, what was interesting is that reporter Maggie Astor, who wrote the article, in the affidavit when she was then under oath in this lawsuit, she changed her tune. Remember? She changed it from solely to many. So they've already admitted that they're lying. And this is the importance of the discovery process, because only when they're under oath, do they tell the truth. It was a glaring admission that we did in fact used named sources. In fact, all we did was show you people talking and show you evidence. But still, the New York Times called our video deceptive and refused to retract after we asked. So we sued. The Times asked the court to dismiss our case and make us pay their attorney's fees. Well, just last week, on March 18th, Justice Charles Wood of New York Supreme Court issued a historic order. Dismissal? Denied. Make us pay their fees? Denied. So let's go. Now, you may remember this. This is the New York Times motion to dismiss. Now, in this motion to dismiss, which the judge has now rejected, the Times had relied upon Wikipedia. They cited Wikipedia to say that we are, quote, libel-proof. What does that even mean, libel-proof? It means that the New York Times is saying our reputation is so bad due to Wikipedia that they can get away with saying anything about us. We confronted executive editor of the New York Times, Dean Baquet, on the street in Los Angeles to ask him, why are you guys citing Wikipedia in your legal motions?
Your lawyer citing Wikipedia. Yes.
New York Times laughing maniacally. You can't even use Wikipedia in high school, in college. Saying that we're libel-proof in this motion to dismiss, Turley writes, it is the type of claim that is highly unlikely to succeed, but has a high likelihood of undermining other claims in the motion to dismiss. Now, the New York Times had argued in their motion to dismiss that labeling us as deceptive was a, quote, unverifiable expression of opinion. Now, the court did not find this quite as funny as Dean Baquet. This ruling is a stunning rebuke of the Times in which the court says the terms, quote, deceptive and, quote, disinformation. The judge says those terms certainly apply to the Times interjecting their opinion in a news article.
Defendants argue that their statements describing Veritas video as deceptive, false, and without evidence were mere opinion incapable of being judged true or false. However, if a writer interjects an opinion in a news article and will seek to claim legal protections as opinion, it stands to reason that the writers should have an obligation to alert the reader that it is opinion. The articles that are the subject of this action called the video, quote, deceptive, but the dictionary definitions of, quote, disinformation and deceptive provided by defendants' counsel certainly apply to Astor's and Shu's failure to note that they injected their opinions in news articles, as they now claim.
You've seen this tactic before. It's what millions of Americans know. The New York Times is guilty of what they're accusing us of.
Remember what we always say on this channel, hashtag confession through projection, because it looks like that is exactly what the New York Times did themselves.
You're guilty of what you accuse me of. It's a psychological, it's like a sign of mental illness. In fact, in a lot of the YouTube comments discussing this case, it's very insightful and speaks to the absurdity of the New York Times argument in the case. Here's one, quote, so the New York Times' defense could have been used against themselves on almost everything they report on. The court has to explain to the New York Times, the supposed newspaper of record, the old gray lady, all the news that's fit to print without fear or favor, that readers read news, quote, expecting facts, not opinion, unquote, and that, quote, purposely designing, unquote, these articles, quote, to appear that defendants are imparting facts and evidence, unquote, is deceptive and disinformation. Opinions are not facts. This is journalism 101. But they didn't just fail me, they failed all of you. The New York Times then argued that if the court didn't buy the opinion defense, that they can prove the term deceptive was truthful. The New York Times threw everything at us.
Attached to defendants' moving papers are over 52 sources. According to defendants, these sources are not just, quote, some criticism from mainstream and or left-wing media, but rather they come from a variety of reputable sources, including Fox News, the Cato Institute, the Los Angeles Times, Newsweek, the Washington Post, and The Blaze. Far from being, quote, some criticism, these sources resoundingly describe Project Veritas as, quote, partisan zealots with a history of distorting facts or context, running cons, misleadingly editing video, and being known for its deceptively edited videos.
The judge in this motion was having none of it.
Attached to defendants' moving papers are over 52 sources. While this is a lengthy media list, polling does not decide the truth, nor speak to evidence.
Polling does not decide the truth. Those are powerful words. We've talked about this problem before. It's the Penrose Stairs problem, a never-ending circle of reporters reporting what other reporters reported, while the other reporters report what the reporters are reporting about the other reporters.
But all of this fits the Project Veritas MO, according to Stanford researchers, who say it appears to be a coordinated disinformation campaign.
The vicious circle of fake news coming full circle. Project Veritas cannot sue us because they are libel-proof, because we've said so many bad things about them that they have to be bad, and they cannot sue us because we said bad things about them.
Or another comment on YouTube. Mainstream media. Veritas is a lying liar pants on fire because our friend said so. But the real power is in what the judge said next.
And defendants have not met their burden to prove that the reporting by Veritas in the video is deceptive.
This is the power of what we do. Our cameras capture the truth, and no mountains of hit pieces can ever change that. The Times gave it their all. 45-page motion to dismiss, 66 exhibits, 3 sworn statements, 3 additional briefings to the court arguing our video was, quote, deceptive. Over 700 pages of supposed evidence of deception. All of it was designed to prove our videos were deceptive, and they failed. Now, if all of that doesn't work, the New York Times then argues, in this case, that they should get a free pass. Now, to even proceed to discovery, you have to show the reporters knew the articles were false, because I'm a public figure, or at least didn't care if they were true or false. Now, this is a high standard to prove because you effectively have to get inside the mind of the reporter to prove intent, but until you get past the motion to dismiss phase of litigation, you don't have the ability to do that.
In defamation law, it's called actual malice, and in this order, the Supreme Court of New York says, quote, Veritas argues that not only does the complaint allege that defendants had knowledge of the falsity of their defamatory statements at the time of publication, but it pleads detailed facts showing the presence of literally every hallmark of actual malice recognized by the law, including setting out with a preconceived narrative, being motivated by ill will and bias, failing to contact obvious sources of information, relying on biased and non-credible sources, violating journalistic standards, and refusing to retract. Veritas alleges that it has far exceeded that standard by pleading overwhelming circumstantial evidence of actual malice.
You don't even get a chance to ask the reporter, what were you thinking? Alan Dershowitz, Harvard Law's Felix Frankfurter Professor of Law, critiqued that a side effect of New York Times versus Sullivan was that people like the New York Times are, quote, free to say anything they want about any aspect of a public figure's life, even if it is totally false. The result of this decision has been open season on public figures and lying about people, and that's why this case is so significant. Effectively, the New York Times versus Sullivan allows the New York Times to tell a court, yeah, what we wrote was false, but you can't prove we knew it was false, so who cares? Most of the time, the judges agree. But not this time.
Veritas documented in its complaint metadata and screenshots that demonstrate the unlikelihood that Ms. Astor read and digested the EIP report blog post, reviewed news reports on Minnesota ballot issues, viewed the video online, obtained comment from Alex Stamos, wrote her own article, submitted it to her editors, and had it posted online, all within 63 minutes. Here there is a substantial basis in law and fact that defendants acted with actual malice, that is, with knowledge that the statements in the articles were false or made with reckless disregard of whether they were false or not.
This is huge. This is huge. We never get to open up their reporter notebooks. But now we have a chance to get inside their heads, and they have to answer our questions, and they, by law, have to comply. Friends, we are inside the New York Times. Now, this is so historic, the New York Supreme Court even commented on the nature of the situation in this order.
Here, one of the largest newspapers in the world since Abraham Lincoln was engaged in the private practice of law, is claiming protections from an upstart competitor armed with a cell phone and a website.
Using words like deceptive and disinformation to describe the New York Times' articles calling us deceptive and disinformation, the court issued a, quote, major victory. Professor Jonathan Tilley, quote, While it has received little coverage in the mainstream media, the conservative group Project Veritas won a major victory against the New York Times this week in a defamation case with potentially wide reach. The decision will allow the Project Veritas access to discovery, which can be extremely difficult for a news organization. The opinion could prove a critical shot across the bow for many in the media that the blurring of opinion and fact could come at a high price. The cost of the changing view of journalism may not only be in the loss of core trust, but of core legal protections. Quote, I expect to be teaching this case next year in my torts class when we deal with defamation. Reporter Michael Walsh of the Epoch Times put it this way, quote, in short, the dam may be breaking. Gadfly Project Veritas won a small but significant victory against the Times the other day. And for more than half a century, the mainstream media has abused its powers under the protective shield of the Sullivan decision. At this point, however, with the national media now weaponized against traditional American law and values, the ruling is no longer a shield, but a sword. The truth, cinema verite, these images here, people talking in their own words, bragging about them breaking the law, that's stronger than defamation. Now, so far, the New York Times, the Washington Post has ignored our win in New York Supreme Court in this defamation lawsuit, but they embrace discovery through defamation litigation when it's weaponized against their political enemies like Fox News.
And so in general, I've been highly skeptical and alarmed by lawsuits that try to stop media organizations from getting information out into the world. But I have to confess, the events of the past few years have started to shake my conviction a bit. As I've watched misinformation run rampant and system after system fail, I find myself hesitantly open to the idea that Eric may be onto something, that the courts may be one of the few tools available.
Do you know, Ben Smith, that our sources in Minnesota feared for their lives to do this? Do you know that we had to put them in hotel rooms because they were afraid for their personal safety? And your organization lied about them and cites Wikipedia and emotion. It's a tragedy, it's a disgrace to journalism, to the First Amendment, that we have to sue you and spend hundreds of thousands of dollars to hold you accountable. But that's what we're going to do, Ben Smith, because we stand up for these people because they have nowhere else to go. They certainly can't go to you or Dean Baquet because you laugh maniacally at them. And you lie about them and you lie about me. But we speak for hundreds, thousands of people like them who have nowhere else to go but places like Project Veritas. And that's why we're going to win. We've already won. We're going to expose you. And if you lied and knew about it, the whole world will see you under oath, having to answer for it. Stay tuned.